I will talk about the legal situation of animals and two ways of changing this legal situation that seem most promising: legislation and litigation. Also, I will argue that these changes in legislation, recent changes in legislation, can be seen as the emergence of a third legal category of sentient beings. This is the outline of my presentation. First, I will talk about the current legal situation and the legal status of animals as things or property. Next, I will discuss some of the arguments for changing the legal status of animals. Then, I will present and discuss recent changes in legislation, modifications in the civil codes of several countries in Europe and beyond that recognize that animals are not things, and those that recognize that animals are sentient beings. I will also discuss what I consider to be the next logical step, which is to recognize that sentient animals as sentient beings have interests and thus are owed universal basic rights. And in the last section, I will talk about a different approach to changing the legal situation of animals, which is by filing lawsuits on behalf of individual animals in order to recognize that they are non-human legal persons. Okay. So, currently, the legal status of animals is in a gray zone. They still fall into the category of things or property, although they're not considered to be mere things, and they're protected by animal welfare laws. On the other hand, there is the category of persons, and the category of persons includes only humans, while animals are the property of humans. Such legal status of animals can be compared to the status of slaves in ancient times, who used to be considered animate property. This is Aristotle's term for slaves. Now, what is wrong with this legal classification of animals is that it objectifies animals in this way, which is not justifiable because they are sentient beings that are distinct from things, and thus should be regarded by the law as sentient beings as well. Thus, I argue that this legal status of animals should be changed because it does not adequately reflect scientific knowledge about animal sentience, and their legal status as things or property limits the legal protection they can have. Now, here are some of the arguments for changing the legal status of animals. First of all, change of the legal status of animals is justified by their sentience, which is the capacity to feel or experience feelings, such as pain or pleasure. Scientific evidence indicates that many animals are sentient beings. First of all mammals and birds, and probably all vertebrate species too, and cephalopods. For this reason, they should be recognized as sentient beings, distinct from things or property. Animal sentience has been recognized by the most important European document of the European Union, which is the Lisbon Treaty of 2009, and also European animal welfare laws. One of the key arguments for changing the legal status of animals is that they have or can have their own morally relevant interests in their well-being, provided they're sentient, of course, which is a prerequisite for having any interest at all in one's well-being. Someone's interests are best protected by legal means, and thus, as long as animals have the legal status of things or property, their interests would not be legally protected and will be systematically ignored for the benefit of humans. Also, arguments for moral considerability of animals can be used, such as the argument for marginal cases, or AMC, arbitrariness or moral irrelevance of the boundary of human species, shared evolutionary history between humans and non-human animals, or evolutionary continuity, and so on. Animal welfare laws take into account animal sentience, but not their interests. And the welfarist approach has proven to be ineffective or insufficiently effective in protecting animals' interests, so different approach is clearly needed. But this situation has started to change, and I will discuss two ways of changing this legal situation: legislation or modification of civil codes, and litigation or filing lawsuits on behalf of individual animals. As for changes in the civil codes, several countries in Europe and beyond have recently recognized that animals are not things or non-things, which is a negative definition or formulation, or even that they are sentient beings, which is a much better positive definition. In the last few decades, these countries have modified their civil codes in order to recognize that animals are not things. First Austria in 1988, followed by Germany, Switzerland, and so on. The civil codes of all these countries recognize that animals are distinct from ordinary things and that they are protected by special laws. And they have the so-called non-thing status. This is certainly an improvement over the false premise on which all of these laws are based, namely that animals are things. This is the provision from the German Civil Code. Animals are not things, they're protected by special statutes, they're governed by the provisions that apply to things with the necessary modifications, except insofar as otherwise provided. Okay, but but these provisions are declarative in nature. Although animals are no longer things legally speaking, they're still treated as things and subject to laws and legal provisions that apply to things. Thus, the legal situation of animals in these countries has not in fact changed, and it looks like this. There is the category of persons, the category of things, and then there are animals which are recognized as non-things, but are in fact non-thing things, which is paradoxical and fall into the category of things. What is lacking here is a special legal category to which animals belong, which would clarify their legal status. And this is the category of sentient beings. And the positive definition of animals as sentient beings is certainly a step forward. These countries have modified their civil codes in order to recognize that animals are sentient beings. First of all, France, Quebec, and quite so on, and quite recently, Spain. France defines animals in a positive way as sentient living beings. Animals are living beings endowed with sentience. Subject to the laws that protect the animals, they are subject to the regime of property. Following the example of France, a year later, Colombia modified its civil code and its criminal code too, recognizing that animals are sentient beings that are distinct from things. Animals as sentient beings are not things. They will receive special protection against suffering and pain, in particular suffering and pain caused directly and or indirectly by humans. This law classifies some behaviors related with animal abuse as punishable and establishes a police and legal enforcement procedure. Okay, these changes seem great, but they are not effective yet in changing the actual legal situation of animals, because they have taken place a while ago, and still they're just a theoretical advance so far. In all these countries, animals are still treated as things, and they can be used as objects or goods, and own as property. As we have seen in the French Civil Code, the second sentence, the last bit, they are subject to the regime of property. But I believe that these modifications should be seen only as the first step to distinguish animals from things in legislation and to recognize or define them as sentient beings. By singling animals out as sentient beings, a new distinct legal category has emerged, the legal category of sentient beings or sentient non-persons, which is the third legal category. I believe that this will enable to overcome the property personhood dilemma that Will Kimlicka talks about. He argues that animals should be moved from the category of property into the category of persons that can bear rights, but as this seems rather utopian, he argues for a third option in the meantime that can help overcome the impasse in legal reforms, which is to recognize animals as domesticated animals he focuses on, as family members or workers with membership rights. But I argue for another third option to move animals from the category of things into the legal category of sentient beings or sentient non-persons, which has already been underway. I believe that this move should be followed by the next step, which is to recognize that sentient animals have interests based on their having interests, they are owed universal basic rights. But how can we justify sorry, I forgot this slide. Okay, animals as sentient beings are interest holders, and as interest holders, they are right holders. And this view that all sentient animals are right holders based on the fact that they have interest is the interest-based conception of rights or approach to rights. Okay, but how can it be justified that all sentient animals have basic rights? Alistair Cochrane argues the case in the following way. This is not a quote, it's a paraphrase. Sentience is the necessary and sufficient condition for having interests. Interests are the necessary and sufficient conditions for possessing rights. Therefore, all sentient beings possess rights because they have interests. It's from his paper, From Human Rights to Sentient Rights. Cochrane suggests that human rights should be reconceptualized as sentient rights. Similarly, Will Kimlicka believes that all sentient animals are owed universal basic rights. I also argue that a significant improvement in the legal situation of animals can be achieved only by such a change, because someone's interests are best protected by legal means, and legal rights are in fact protected interests. Okay, so this is one way to go about it, to move animals out of the category of things, property, and into the legal category of sentient beings, and to recognize that they are right holders as interest holders. A different approach to changing the legal situation of animals is through litigation, which has been used primarily in the countries in South America and the United States, countries with legal systems based on case law. The idea is to file a lawsuit on behalf of an individual animal, such as a great ape or intelligent mammal like elephant, in order to free them. Stephen Wise from Non-Human Rights Project advocates changing the legal status of at least some animals in order to recognize that they are non-human legal persons with fundamental rights to bodily integrity and bodily liberty. Okay. These lawsuits are based on the common law procedure, habeas corpus. The argument is that captive animals are in fact imprisoned, and this is a legal instrument used for determining the legality of someone's detention. It has been used for centuries to free people, and in 2005 it was used for the first time in a lawsuit aimed at releasing an animal. There have been several court cases so far discussing the legal status of animal and its right to freedom. I'm sure you're familiar with some of them, so I'll mention just a few that can be considered a milestone in the field of animal rights. First of all, historic court ruling in 2014 in Argentina approved the release of orangutan Sandra, and the court recognized that she had been unlawfully deprived of her liberty. Sandra was also granted the status of a non-human legal person who deserves basic rights such as the right to freedom, the right to life, liberty, and freedom from torture. Another example from South America is the lawsuit from 2016 filed on behalf of a chimpanzee, Cecilia, from the Mendoza Zoo in Argentina. It also used the writ of habeas corpus, and it was ordered to release her from the zoo and transfer her to a sanctuary for great apes. The judge declared that Cecilia is not a thing, but a non-human person subject of rights that are inherent in sentient beings. Okay, so this is my proposal. There is the category of things and the category of persons, which apart from humans should include non-human animals with complex cognitive and emotional capacities, such as great apes and intelligent mammals that deserve a special legal status of non-human legal persons. As for other sentient animals, like other mammals, birds, and cephalopods, they need to be moved into the third legal category of sentient beings or sentient non-persons that can bear rights. To conclude, these are my main theses. Animals as sentient beings are distinct from things, so their legal status as things is not adequate or justifiable. First step includes modifications in civil codes in order to recognize that animals are not things but sentient beings, which is a new third legal category. Next step would be to recognize that animals as sentient beings have morally relevant interests and thus are owed universal basic rights. Litigation can help change the legal status of some animals to recognize that they are non-human legal persons. It can also indirectly initiate changes by drawing attention to this problem, which can lead to public and professional debate and result in changing the legal status and the laws relating to the legal status of animals. These are some of the references that I used. And this is my cat saying thank you for your attention.
Thank you so much.
Okay.